Hi guys, AJ here coming at you with some more IP. Welcome to week 3, and this week's kind of exciting for me because we'll be going through confidential information or trade secrets and also patent law. Yay! Firstly, before we jump into the key concepts that I want you to take away from your readings in Fitzgerald and Eliades this week, just a little bit of a primer or a background on confidential information and trade secrets. As I've said in the weekly notes for this week, yes, it is quicker and cheaper, if you will, to protect your trade secrets just by keeping them secret. However, that doesn't necessarily mean that it's going to be easy to protect them down the track. And you need to have taken certain measures to protect your confidential information, to keep it confidential, to keep it secret. So you'll find companies that do choose to take this route to protection of their intellectual property will impose some reasonable safeguards to protect the quality of their information, the secret quality of their information. So in companies you'll find routinely things like encrypted files, you'll find password protected files, you'll find the company's databases being segregated for use by only a certain number of people. You may find physical protections like the pass swipes to get into a room to use certain databases or certain software. You may find obligations of confidence in the employment contracts. You may find surveillance of employees to ensure that they're sticking by their obligations and what they are required to do. So all of these things don't necessarily mean that keeping a trade secret is the cheapest or easiest option, but nevertheless those kinds of safeguards are necessary in order to protect your confidential information. Now, in terms of intellectual property protection, trade secrets or confidential information are not recognised in Australia as a proprietary right. I think they've kind of nudged closer to that with the US legislation, but certainly here in Australia, not yet recognised as property, and therefore we are thrown back on the two main points that we take away from Fitzgerald and Eliades for this week. So you're either going to be protecting your trade secrets by way of contractual obligations of non-disclosure, or you're protecting your confidential information, unfortunately, ex post, that is after the fact. You're protecting that confidential information by way of the equitable action for breach of confidence. When you're looking at the equitable action for breach of confidence, what I want you to take away from that particular part of the chapter is the difficulties in succeeding in that kind of action. Particularly, many of those kinds of actions will fall down on the first step. That is, the plaintiff can't actually prove that their information has the necessary quality of confidence, or they will fall down on the second step, which is proving that the information was disclosed under an obligation of confidence. The other thing too is that whether you're protecting your confidential information by way of contract or you are relying on that equitable action, neither will really protect you from somebody else that comes up with the same idea, the same trade secret, independently of you, and there's nothing to stop them going out to market with that independently derived information, and there is nothing to stop a third party from reverse engineering your secret information if you already put it out into the marketplace. Okay, so not necessarily an easy way of protecting your information, as I said at the start. So that's really all I wanted to say about confidential information. Now let's turn to look at some patent law. Okay, so there's a couple of things that I want you to note about the discussions in Fitzgerald and Eliades in the patent chapter. And the first one is the fact that they talk about patents being a monopoly right. You'll see this in academic writing everywhere, you'll see it in the media. However, you need to be fairly careful with the way that you use the word monopoly. In section 13.1 of the Patents Act, you'll find that it states that a patent gives the patentee the exclusive rights during the term of the patent to exploit the invention and to authorise another person to exploit the invention. Now, the words to note there are the invention. The only thing that you actually get exclusive rights to use are the particular claims that relate to your particular invention. What it doesn't guarantee is that you can actually go out to market and successfully commercialize that invention. It does not guarantee you what they call freedom to operate. So if, for example, your patent claims trespass over the top of another patented invention, then you are going to have to go away and get a license from that patentee whose ideas you are borrowing and perhaps incorporating into your invention before you can march out into the marketplace and commercially offer your invention with any degree of certainty that you won't be sued. Okay, so just because you have a patent on an invention doesn't give you freedom to operate. Okay, that's the first thing that I want you to notice from the discussions there. Secondly, in relation to the chapter itself, it's a good idea for you to go through all of the technical requirements in terms of provisionals and completes and priority dates and so forth. But the big ticket items that I want you to take some careful note of are the main requirements for patentability. Okay, so firstly we have the discussion in the text of manner of manufacture. Now, as I say in the notes, this is quite a quaint term that has been floating around for years and years, ever since the statute of monopolies. And the discussion in the text is somewhat overtaken. Yes, the NRDC case law still actually applies, so the test from that case as to whether or not your invention is going to be a manner of manufacture is whether or not it's an artificially created state of affairs of some kind of use in an area of economic endeavour. Okay. There have been many, many subsequent applications of that test. However, in Darcy and Myriad in the High Court, you will see that the High Court says, hang on a minute, we're starting to get a little bit too prescriptive when we use this test. Don't let it rigidly guide your decision making. These are not the only factors we need to be thinking about when we are thinking of answering the question as to whether an invention is patentable subject matter. Of course, in that case, they were looking at a very sensitive patent, a highly controversial patent by Myriad Genetics over the BRCA breast cancer genes, and the plaintiff was actually a breast cancer sufferer, so the whole case was fraught with some sense of emotional investment. And what they said there was you really need to look at factors apart from the NRDC factors, like whether or not the invention would give rise to a large new field of protection and therefore stifle innovation. Would it have a chilling effect on activities beyond those of the patentee's activities? Would the grant of a patent here involved the court assessing important and conflicting public and private interests and public and private purposes. And also you need to think about things like coherence of the law and whether this is the kind of decision making on patentable subject matter that really should be done by the legislature rather than the judiciary. And in that case, genes were actually held to be an artificially created state of affairs. However, the nature of a decision by the court that that particular subject matter was patentable subject matter, they said really was the kind of thing, because of its wider social impact, that was more appropriately dealt with by the legislature rather than the judiciary. And therefore they held that it was not in fact patentable subject matter. Now, of course, that put the whole biotechnology industry in somewhat of an uproar. It took quite some time for the Patents Office to decide how they were going to apply that case in practice. They held some public consultations on it. It looks as though the decision will be reasonably strictly applied. And I've got some materials there in your weekly notes if you wish to hunt up some further information on that. Otherwise, just ask me in the next Zoom session. So that's the issue of manner of manufacture. You need to bear in mind that Darcy and Myriad case, because that has come down subsequent to publication of the Fitzgerald and Eliades text, which is what I mean by IP moving so quickly. The other tests that are relevant for you to take note of are both novelty and inventive step, and I'll say a little bit more about inventive step in just a second when I talk about innovation patents. The other ones are utility, so your patented invention has to be useful. It has to have some kind of specific, substantial and credible use now since the Raising the Bar Act. Also, there can be no secret use. And this one I really want you to take note of in terms of our prior discussions on confidential information. So you can see here, if one of the criteria for getting a patent is that there must have been no secret use, this means that you can't go the whole trade secret kind of confidential information route first with your invention and take it out to market, make some money on it, and then go, oh, well, I've kept it secret. So it'll still be novel for the purposes of the novelty requirement in the patents legislation. That really would be an artificial extension of your proprietary rights in your invention if you were to get then another 20 years worth of full-on, very strong patent protection on top of the period that you've had exploiting the invention, just keeping the manner of operation or the ingredients secret. Okay, so necessarily the whole idea of keeping your invention a secret is at an odds with being able to patent that invention. Okay, so you really need to choose one or the other for the main bulk of your invention. Now, there is one way that you can still retain some advantage by secrecy, and this is by certain know-how that might go into the operation of your invention. What you can do, you still have to disclose the best mode of operating your invention, but if there is some other associated know-how that might go around the development or the operation of your invention, then you might be able to still protect that by way of secrecy there. So as an example, the very famous drug Valium was patented many, many years ago. That drug came off patent. However, it still retains an extraordinary market share. And there has been some speculation that even though there are generics available on the market, they're not quite as effective as the original patented brand of Calmative. And so it may well be that there is some know-how around production of that drug that increases its efficacy somewhat. And also, obviously, the thing that helps the Valium brand retain its market share is the brand. So here we tie in nicely with next week's work. So trademarks certainly come into play when you are launching your product so that you can develop a strong brand loyalty so that when your patent drops away, you can still maintain your market share by maintaining that brand presence in the marketplace. So that is the idea of no secret use. Anyway, that's probably all we need to talk about in terms of patent law for this week. If you have any other queries or questions, just shoot them through to me either in an email or in a forum or via tweet. The only other thread of discussion that I just quickly wanted to touch on before we go is the idea of an innovation patent. And really, these things, they're not hugely popular. There are a relatively low number of them granted each year. However, most of these are actually granted to Australian residents rather than the standard patents, which are kind of overwhelmingly granted to international patentees. The main difference between the two is that the innovation patent has an 8-year term and the standard obviously has the full 20-year term. The other major difference is the examination process. So for an innovation patent, really it's just a formalities check. Have you spelt your name right? Tick. Have you paid us the fees? Tick. I mean, that kind of thing. There's really almost no checking that goes on. There is no pre-grant opposition period for an innovation patent. So it's a pretty smooth sailing process. The only thing is that once you have your innovation patent granted, you can't actually enforce it until the innovation patent has been certified, and that is an examination process that you need to go through. The main, I guess, differentiating factor there is the difference between an innovative step and an inventive step that's required for a standard patent. So for an inventive step for a standard patent, you are looking at a much higher level of inventiveness to demonstrate to the patent office than an innovative step. So for inventive step, you need to assess the invention in light of the common general knowledge and the prior art that's out there in that inventive space. And you have to ask yourself whether the invention would have been obvious to a person that's skilled in the art in that particular inventive space. So if someone that's working in that field would have thought, what's the next logical step in the evolution of this particular widget? I think it's X, and you've suddenly decided to put your hand up and patent X, then it will fall down during examination for lack of inventive step. However, an innovative step is much lower, and that requires simply a comparison with the prior art base, and you will have sufficient innovative step if your invention makes a substantial contribution to the working of the product or process. And here, even obvious combinations of well-known features are acceptable. So you can see a much lower hurdle to clear for an innovative patent, designed specifically for that reason, to make it easier to secure. And in return, you're going to get that much lesser term of 8 years worth of protection. So that's patent law, innovation patents. Like I said, any questions or queries, just let me know. Other than that, if you enjoyed the video, please give it a big thumbs up and subscribe, and hopefully I'll get to chat with you soon. Thanks, guys.